Dear students, viewers and the subscribers, welcome to the IAS Mentor. This would be our lecture number 114 in the series Indian Polity, and we'll continue discussing the statutory bodies. Last class I started the statutory bodies, we'll continue with that. But however, before going to the topic, I wanted to make the announcement that based on the request which is made by a number of students, I'm planning to do a current affairs series for the prelims 2025, majorly from the subject polity. And this current affairs series would cover the most important and most relevant topics from May 2024 till April 2025, which would 1 year of current affairs. So in order to maximize the chances of the students to get more marks from the subject Indian polity, and I'm quite sure that if you have followed the Indian Polity Series along with the current affairs series, 80 to 90% of your questions can be got right, provided you also do a multiple revision of the material and all those things. It will definitely help you. So with that information, I'll just go to the topic today, that is the statutory bodies. As I've been telling number of times that this series is going to be extremely useful to the students who are preparing for both UPSC examination as well as other competitive examination, including the state public service examination. And in the coming years, I'm sure that it will benefit lakhs and lakhs of students, because each and every lecture is curated by me and it is presented in a precise manner which the students have to observe when it comes to the examination. Alright, so with that, I'll just get into the topic for today. So if you see in the last class also I have discussed the statutory bodies. In the last class I have discussed 4 important statutory bodies. I have discussed about the Human Rights Commission. I have discussed about the National Commission for Women. We have discussed also about the National Commission for Minorities and the National Commission for Protection of Child Rights. So these are the statutory bodies I discussed in the last class. So today I will discuss 2 statutory bodies, basically 3, but it is based on 2 important laws. One is the Right to Information Act in our country 2005, which allows for establishment of both Central Information Commission at the central level and the State Information Commission at the state level. And apart from that, another important statutory body is the National Investigation Agency, NIA, which is again established based on the law that is made by the Parliament. Today, NIA is a premier institution in our country to deal and to investigate into cases related to terrorist activities in our country. In fact, this National Investigation Agency Act was passed after the Mumbai terror attack, and subsequent to that the government of India realized that they need to have a specialized agency to deal with terror related investigations in our country. Alright, so this is just a preliminary introduction to these bodies. Let us try to understand them further. First, I'll start with the Central Information Commission. As I already said, both the Central Information Commission as well as the State Information Commissions in various states, they are established based on what is called as the Right to Information Act. So before I go to the Information Commission, let me briefly discuss about the Right to Information Act 2005 and what is the objective behind this act. And in fact, to achieve this objective, the commission is established under this particular act. Even before the Right to Information Act, the government of India came out with an act which is called as Freedom of Information Act in 2002. But this Freedom of Information Act never became a reality because this Freedom of Information Act was never notified by the government of India. And then they brought in an upgraded and improved version of this law is what is called as the Right to Information Act 2005. So as the name suggests, what is this right to information? This Right to Information Act provides a legal right to each and every citizen to seek what is called as, that is the right to seek public information or the right to seek information from the government. While each and every citizen of our country will have the right to seek information from the central government, they can also seek right to information from the state government as well. Of course, this information may not be related to the personal domain of other individuals, but which can be published in public domain. Such information can be sought. Now it has become a part of the right after this Right to Information Act was passed. Therefore, whenever the citizens file such a request seeking information from the government, say for example, you as a citizen, if you want to know how much money has been spent in the budgetary process and in the budget where specifically the money has been spent for education, how much has been spent for health. Suppose if you want to know about the Mahatma Gandhi National Employment Guarantee Act, you can file an RTI to the government. This year, how much amount has been given to the Mahatma Gandhi National Rural Employment Guarantee Act, and further subdivision can also be sought. How much money has been allocated to various states? So all these questions can be sought. I am just giving an example through what is called as Right to Information Act. Suppose if an examination is conducted, you can ask how many students have applied, how many students have qualified, if any qualified student was not issued the appointment. So all these information can be sought through the Right to Information Act. So basically it is your right under the act to seek information from the government. And the very objective of this Right to Information Act is not only to empower the citizens to seek information. Therefore, by empowering them, you are also making the system of government more accountable, answerable to the people. So it's a classic tool of bringing in what is called as both transparency as well as accountability in the system of governance. So that is the objective with which the Right to Information Act was passed. So that means it today empowers every citizens to seek the information. So when they seek the information, who has to dispose this information? It will go to a government authority and they have to dispose this information. So for that purpose, this act mandates that every government department should have a public information officer who is also called as PIO. So PIO is nothing but the public information officer. It will be the responsibility of this public information officer to provide the information to the citizens. So that's basically what you'll have to understand about the public PIO. So the PIO is the nodal authority to dispose the petitions that has been filed to the government seeking the information. Suppose in case if the PIO is not giving the information, so under the law there are certain areas where the information is exempted. Say for example, if the law is related to, if the information is related to national security, if the information that we are seeking is related to some of the defense forces in our country, if the information that is sought is being related to privacy, right to privacy of an individual, or if the information that an individual is seeking is not related to his own personal domain. So in certain cases the information may be exempted, but it is not in all the cases. Most of the cases the information has to be given. There are certain exempted information. So, but if an information is sought to the PIO, for some reason the PIO is not giving the information, you need to have an appellate authority. So who is appellate authority against order of the PIO is usually his own senior officer, immediate senior officer. Normally for most of the government departments, it is the assistant secretary or an officer below the assistant secretary is a PIO. There is no hard and fast rule. Assuming that the assistant secretary is a PIO, then the first level of appeal is to the deputy secretary of the concerned department. So we can make an appeal against order of the PIO to the deputy secretary, assuming that he is the appellate authority. And in this case also, the authority is not giving the information, then the next level of authority, appellate authority, is the State Information Commission or the Central Information Commission. So what does it mean by State Information Commission or the Central Information Commission? Depending upon from which ministry or which government you have sought the information. If you have sought the information from the state government, so the next level of appellate authority is the State Information Commission. If you have sought the information from the central government, the next level of authority would be the Central Information Commission. So for this particular purpose, there is a need for a commission. So that is the reason the Right to Information Act allows for what is called as Central Information Commission and the State Information Commission. So they are the one they have to take the appeal against the orders which is issued by the government officers, whether they have given the information or not given the information. Sometimes it is not only with regard to rejection of the petitions filed by the citizens by the government authorities, but the sufficient information has not been given. Partial information is only given. In all these cases, they can go to the appeal to the concerned authority. So in this case, it is the State Information Commission or the Central Information Commission. Even if you are not happy with the decision which is given by the Information Commission, then the next level of appellate authority is a High Court concern. And against the order of the High Court concern, the next level of authority is the Supreme Court of India. So the Supreme Court of India is the highest authority where you can take this particular matter if the information is denied, or if the information that is given is partial, or if the information that is given is concealing certain facts which you think is the case. So to provide for all these mechanisms, a law is enacted, and the law has also allowed for establishment of the Central Information Commission as well as the State Information Commission. But apart from this, the Central Information Commission and the State Information Commission does perform other functions also, and to that extent they are also empowered by the law. So what we will do is, as we will proceed, first we will try to understand the composition of the commission with regard to the membership, how they are appointed, their service conditions, and then their powers and functions. And the same thing we will do it for the State Information Commission also, and then we will move on to what is called as the National Investigation Agency. Alright, so with that we will just enter and try to understand the composition of the Central Information Commission. As I already said, established under the Right to Information Act. If you see the composition of the Central Information Commission, the Central Information Commission shall not consist more than 10 members or 10 information commissioners and one Central Information Commissioner. So there will be one CIC similar to that of the chairperson of the commission, and then it will have not more than 10 information commissioners. So the maximum limit is 10 information commissioner. It can be less than that also. Okay, so CIC plus 10 information commissioner. And all these members are appointed by whom? By the President of India. And the President of India appoints all these members based on the recommendation which is given by a select committee. And who constitute this select committee? The select committee is headed by the Prime Minister. So normally I use the word select committee. So what does it mean by select committee? Select committee normally means that these are the members that who will recommend the President. So they will shortlist the profile and they will recommend the names to the President who are to be appointed to the commission. So it consists of the Prime Minister, the leader of opposition in the Lok Sabha, the Union Minister nominated by the Prime Minister, usually a Union Cabinet Minister nominated by the Prime Minister. So these three people will be part of the select committee. And as per the practices that we have today in our country, who is given the leader of opposition in the Lok Sabha, and to have or to enjoy this particular status of leader of opposition in the Lok Sabha, the leader of that particular party should have a minimum number of strength in the Lok Sabha. So if you know the answer, please put it in the comment box. So I am not going to discuss about this because in my previous number of lectures I have discussed about this. So students those who are aware of the answer, you just put it in the comment box as to when a person can be appointed as a leader of opposition in the Lok Sabha, and for which how much majority or how much strength that particular political party should have in the Lok Sabha. Apart from that, the law is also saying, be it the Central Information Commissioner or the other information commissioners, to be appointed to the commission, what is experience they should possess? They should be experienced in the areas of law, science, management, governance, social service, etc. And apart from that, a member of parliament or someone who is occupying an office of profit should not be appointed as a member. So no MP, no sitting MP, no sitting member of state legislature, be it legislative assembly or council, or someone who is occupying an office of profit. So what is an office of profit? Any office either under the center, state, or any of the other local authorities by way of which a profit is receivable. So therefore anybody occupying such an office cannot be appointed to the Central Information Commission. And what shall be their term? So this is very important. So in 2019 this law was amended, although it was brought in the year 2005. In 2019 certain changes have happened to this particular act, and in 2019 it was amended and they changed the term of not only the Central Information Commissioner and other information commissioners, but they also changed the term of the State Information Commissioners as well. So today they do not have a fixed term. So who will determine their term? The term may be determined by the Government of India at the time of their appointment. So the Government of India can make rules. So the Government of India may prescribe, that is the central government may prescribe their rules by rules as to what is their term, or until they attain the 65 years of age, whichever is earlier. So if the Government of India prescribes a term, then that is a term. If he does not prescribe, maximum from their appointment till 65 years, but in any case whichever is earlier. So that is there in the law. So who is going to determine the term? It is the Government of India. Alright, and they are not eligible for reappointment. So this is also very, very important. That means once they retire from the commission, then they are not eligible for the same post from where they have retired. Their salaries, their allowances and other service conditions are to be prescribed by the central government. So that means today the government has lot of control over the salary and the service conditions of the members of this commission. In fact, because of this amendment which has happened in 2019, there was a lot of criticism also that by allowing the central government to prescribe the terms and conditions, by allowing the central government to determine the service conditions, it may have an impact upon the independence of the Information Commission. So this is what the critics have said. So the students are watching this video. If you think yes, if the central government is exercising the power for this, do you think that it will have an impact upon the independence of the Information Commission, which plays a very important role today under our political system? So if you think so, you can put your comments. You can put as to what you think regarding this in the comment box. Your comments are most welcomed, because this is how we can learn a lot of new things, because I can also have a lot of insights based on what you are thinking about these things. And then if you look into the law also says that the members of the commission can be removed by whom? By the President of India. And what is the ground on which they can be removed? If they are engaged in any paid employment outside the office, and apart from the paid employment, if they turn out to be unsound mind, if they suffer from any mental disabilities, if they turn out to be an undischarged insolvent, or if they are convicted of any offense, and also on the grounds of misbehavior and incapacity. Now you can see that most of these grounds are similar to that of the grounds we have seen in case of the Human Rights Commission, because these are all statutory bodies, so almost similar grounds in the law. All right. So this is the term, the service condition, how they are appointed. So these are all very factual area, very relevant for your prelims examination. But moving forward, we should also have an understanding as to what are the functions that they are supposed to perform. What is a major function that they are supposed to perform? The major function that they are supposed to perform is how the law is actually getting implemented. Is the law getting implemented properly? Is the public information officers in various government departments and agencies, are they providing the information? If they are not providing the information, a further appeal can be made. Against order of the appeal, then it comes to the Central Information Commission or the State Information Commission. So whenever such appeal comes, they have to look into these appeals and they have to pass orders. This is in fact one of their major functions. So this is the major function that is performed by the Central Information Commission. And to perform this function effectively, in fact, the Central Information Commission has most of the powers as that of a civil court. They can summon officials, they can take evidences on oath, and apart from that, they can seek any public records. So all these powers are given to the Information Commission. And in fact, the Information Commission can also take up cases suo moto on whatever I have discussed. So these are all some of the powers, and this body today has a very important statutory position under our political system. All right. So this is basically what you'll have to understand with regard to the powers and functions. A similar function is also performed by the State Information Commission at the state level. But before we go to that, let us also try to understand about the composition of the State Information Commission. So what is the composition of the State Information Commission? It shall consist of a State Information Commissioner, State Information Commissioner, and other not more than 10 Information Commissioners. Okay, so it is not SCIC, it is SIC, State Information Commissioner, and not more than 10 Information Commissioners. And all the appointment is made by the Governor of the concerned state. And here also there is a search committee which recommends the name for their appointment. It shall be headed by the Chief Minister, the Leader of Opposition in the Legislative Assemblies, and a State Cabinet Minister nominated by the Chief Minister. So this 3-member select committee will recommend the names, and those names are binding upon the Governor. So normally who shall be recommended? Anyone who is having experience in the areas of law, science, management, governance, social service, etc. And they should not be an MP, a member of parliament, or a member of state legislature. So that's again very important. So anyone who is a member of parliament or a member of state legislature should not be appointed there. And he or she should also not have any office of profit. So that is also true. If they have any office of profit, then they cannot be appointed. So this is similar to that of what you have seen in case of the Central Information Commission. And of course, their term may be prescribed by whom? Their term may be prescribed by the central government. So this is again brought in by the 2019 Act. Their term may be prescribed by the central government, not only for the Central Information Commissioners, but also for the State Information Commissioners who will prescribe their term. It is only the central government, and they or till they attain what is called as 65 years of age, whichever is earlier. and they're not eligible for reappointment. So this is again the same thing that you have seen with regard to the Central Information Commissioner. Their salaries, allowances and their conditions of service are all prescribed by the central government. So both the things was brought in by an amendment that has happened to the Act in 2019. All right. And here how they can be removed? They can be removed by the governor. And what is the ground? Almost on the similar grounds. Paid employment outside the office, unsound mind, insolvent, convicted of any criminal offence, misbehavior or incapacity. While the grounds are same for both the members of the Central Information Commission as well as the State Information Commission. But who shall remove them? In case of the union, that is the Central Information Commission, it is by the President. In case of State Information Commission, it is by the Governor. So I am sure that it is quite clear to all of you. So the State Information Commission performs the same functions. In fact, they hear appeals which is coming from the government, and wherever the information is not given or wherever the information is concealed or wherever the petitions have been rejected, such appeals will be taken up by the Central State Information Commission at the state level. And they can take up the matter suo motu also and give such directions to the government authorities. So this is basically what you'll have to understand with regard to the State Information Commission. And to perform and to exercise this power to this duty or this function, they have almost the powers of a civil court. They can summon anyone, they can take oath on affidavit, evidences on affidavit, and of course apart from that they can also direct the authorities to give the information if the information is not given. So all these are the functions of the State Information Commission as well. So with that we are coming to the end of the Information Commissions. Very important, a statutory body that is established under the Right to Information Act. So now we are moving to the next statutory body, a very important investigative authority today under the constitutional system in our country is the National Investigation Agency. In fact, there was no such body which is called as National Investigation Agency, and most of the terror related cases were taken up by the local authorities, or I would say not the local authorities, which mean by the state government. The police, the state police was taking up the inquiry, and they coordinated with multiple agencies in our country. But during the Mumbai terror attack in 2008, after that the government of India realized that they need to have one centralized body to deal with the cases related to terrorism, which was hailed as a historic step by most of the experts. One centralized agency. So therefore there can be effective implementation and effective intelligence collection when it comes to terror attacks in our country. So to that effect, the National Investigation Agency Act was passed in 2008, and by that act they established what is called as a National Investigation Agency. And today this National Investigation Agency has jurisdiction throughout the territory of India. Wherever there is a terror attack, and the National Investigation Agencies can go anywhere and they can carry out the investigation. And in fact, one classic feature of this particular act is the National Investigation Agency can move anywhere within the territory of any state and start investigating even without the permission of the concerned state, because a terror attack is related to the national security concern. So therefore, there is no need to take the permission. But however, the general rule is when any central authority mostly goes to any of the states, they need to take the permission of the states. So for example, this is true in case of CBI also. The CBI, when they have to enter into a state, they have to take the permission of the state government. But however, there is no such restriction to the National Investigation Agency because the law provides for it. So when the National Investigation Agency was appointed initially after the 2008 Act, their primary and their only function is to deal with terrorism related cases. So what are the major cases? They will deal with terror related cases which is related to bomb blast, hijacking, attack on important installations of vital national importance. So mostly related with the national security and the terrorism related acts. But however, over a period of time, today the scope and the functioning of the National Investigation Agency has been expanded, and now lot of other things have also brought within the jurisdiction of the National Investigation Agency, which include cases related to counterfeit currencies or fake currencies, which includes cases like human trafficking that is happening in India. Cyber terrorism and cyber attacks related cases are also brought out in the jurisdiction of the National Investigation Agency, which means you can understand the successful investigation of the NIA that has led to expanding the scope of the National Investigation Agency. In fact, the NIA is headed by an officer of the rank of Director General, and the NIA is directly under the administrative control of the Ministry of Home Affairs, the Union Ministry of Home Affairs, and directly in charge of the Union Home Minister. So therefore, you can understand that bringing such a body, a specialized body to deal with specialized threats to our country is a very good step that the government has brought in. So these are all the things that you'll have to understand with regard to the National Investigation Agency. So we discussed two important statutory bodies. One is the Information Commissions, that is both the Central Information Commission and the State Information Commission, and we also discussed about the National Investigation Agency. So both are very, very important from your prelims point of view. Sometimes a question may come from the Right to Information Act and the respective commissions in your mains examination also, because it is also related to a concept of transparency and accountability, which is also part of your governance part. I'll discuss about all those things at the later stages. So that can also be a possibility. All right. So with that, we are almost coming to the end of the discussion, but not without discussing this particular question. Okay. So please have a look into the question. Consider the following statements. The Central Information Commissioner and the State Information Commissioner are appointed by the Prime Minister. Is it by the Prime Minister? Statement 1. Statement 2. The Central and the State Information Commissioners have a fixed term of 5 years. Do they have a fixed term of 5 years or not? Come to statement number 3. The Central and the State Information Commissions are bodies established by an executive order. So which of the statements given above are correct? So you can see that one among them is the answer. You can put your answers in the comment box, and those comments are going to motivate me. So before I wind up the lecture, as I already said, in addition to the Indian Polity Series, I am also planning to start a series on Indian Polity Current Affairs, which is most relevant current affairs will be discussed, and especially focusing and to help the students appearing for the prelims 2025 examination. And for more information on this current affairs series, you can subscribe to the YouTube channel, the IAS Mentor. Thank you very much and all the very best.